which may make any non-lawyers actually yawn, but they are important precisely because they are cross-cutting. In other words, they don't fall into any of the specific categories, the area-based management, EIAs, capacity building, or technology transfer. And I'm not going to talk about them all, probably to Cindy's horror, but, but I will talk about principles, relationships with other instruments, and the important question of not undermining. I don't know if you talked about that yet, but okay, we're going to talk about it here. Dispute settlement, touching on monitoring, reporting and review, responsibility and liability, and the issue of non-parties, and some governance considerations. So these are the sorts of things that, when we talk about cross-cutting, that we do talk about. One of the other important ones is called final clauses, and I won't be talking about that because that will really only get lawyers like Simi excited and Methodists for today's OPA. So, but what was important is in IGC1, the chair, or the president expressly left out cross-cutting from her paper, but did add some cross-cutting issues at the end of each cluster. So, principally, the preamble, scope of application, financial resources and issues, compliance, dispute settlement, responsibility and liability review, and final clauses were not included in the last president's paper, and therefore were not discussed in any great detail in IGC1. Now, touching on principles, why do we have principles? And you know, they essentially systematise the rules within the legal system. They specifically set up measures concerning the rights and obligations of states, set up normative frameworks integrating different considerations, and provide guidance, most importantly really, provide guidance for the interpretation and application of rules in the instrument, and as well as set out the critical ways or pathways that the objective will be achieved, and provide context for the rules. And these may seem obvious, but certainly there's some schools of thought that hold that we shouldn't have principles at all in the agreement. So I think it's worth emphasising what their role is, because I certainly believe they're important. And High Seas Alliance wrote 2 years ago a paper called Addressing 10 Governance Principles, which we've identified. So these evolve a little bit, but essentially I think we think these encapsulate what we really need to address. So firstly, the protection and restoration. It's really important because if you look at the Law of the Sea Convention, it talks about protection, it talks about preservation, but not restoration. And so protection and restoration of the health, biodiversity, productivity and resilience of the oceans and marine ecosystems. And then secondly, sustainable and equitable use of marine life for the benefit of future and present generations, so bringing in intergenerational equity into play. Promoting cooperation, which is kind of obvious for BBMJ, I think we talked about that. Best available scientific information, same thing. Stewardship. Now this is a tough one because we have tried as hard as we can to come up with a overall guiding framework, if you like, for BBNJ, and that's important because, particularly with marine genetic resources, there's a very live issue as to whether the marine genetic resources are the common heritage of mankind under the convention, and essentially, without getting too boring about it, the G77 maintain that they are, but everyone else says no, they're not. And the reason they say no, they're not is because resources are defined specifically in Part 11 of the agreement to mean minerals. But the G77 say, well, that's a load of rubbish because the area is common heritage of mankind, and the marine genetic resources are part of the area. However, and this is a big but, when you're talking about marine genetic resources, most of the marine genetic resources are not actually on the sea floor. Most of them are in the water column, particularly, for example, within hydrothermal vents, all sorts of interesting bacteria and viruses and whatever people wanted within the hydrothermal vents. And the definition in Article 77 of UNCLOS of sedentary species is effectively whether the species are in constant contact with the seafloor at the time of harvest, which is a completely meaningless definition for our purposes. But what's important to remember is that, and this is why I keep saying to the G77, is that if they stick with common heritage of mankind, you've only got the seafloor, and therefore you'll lose the rest of the water column, which is a problem. It's also a problem for us because, I think you will simply not get the United States, UK, France, etc., to agree that the whole ocean is common heritage of mankind or humankind. It would be lovely if we did. And in fact, there was one wonderful moment in the International Seabed Authority celebrating the 30th anniversary of the Law of the Sea Convention, when they had a whole lot of T-shirts printed which said, ocean, the common heritage of mankind. We bought almost all of them that we could buy, but then Michael Lodge soon realised his mistake. But so what we've tried to do is come up with another paradigm. We suggested common concern. Most states believe that's too weak. China has suggested common interest, and they say that because that brings in use as well as preservation.
What was it?
Common interest is what China's suggested. We say common concern, but again, most states have pushed back saying they think it's too weak. So for now, we're putting this there as stewardship. But if anyone has any better ideas, then please let us know. The precautionary principle, pretty obvious, although the important thing is precautionary principle, not precautionary approach. And we say that because the principle is specifically enforceable, whereas an approach is just something which is pretty airy-fairy. And we have support of the UK surprisingly in that one, as well as the group of as well as the Africa group, I should say. Ecosystem-based management, I think it speaks for itself. Good environmental governance, including principally transparency, and what are called the three pillars of the Aarhus Convention, which are access to information, public participation, and access to review procedures. The polluter pays principle, one which is quite surprising. We've had a lot of support on so far, so touch wood. It's still in there, even though there are not that many conventions that apply the polluter pays principle, and respect for the law of the sea. And just to touch on, I think we don't specifically need to go into this in great detail, but just to point out, as I see it, your matrix of activities, threats, and governance, and particularly because Peggy, we do need to talk about institutions a little bit here, do we?
Yeah, I think
that
makes sense.
Yeah.
Unless I think Christina and Nicola will be covering that.
Oh, good. Okay,
Yeah.
I'll just only touch on that. So in that case, you've got your current institutions on the right-hand side, your Seabed Authority, BBNJ, RFMOs, and the United Nations General Assembly, and then various threats such as climate change, ocean acidification, deoxygenation, plastics and pollution, and so on. And so the question becomes, how do they react? And I'm sure you've all talked about fragmentation of institutions and how they all do or don't talk to each other. And we've had that slide before. So what I want to talk about now is this crucial issue of how the BBNJ relates to sectoral and regional organisations, by which we normally mean regional fisheries management organisations, or RFMOs, and things like the Seabed Authority or the IMO, the International Maritime Organisation. And this is a big fight because in the various PECCOMs leading up to the IGC, Iceland in particular, supported by Japan, South Korea and Russia and others, would say, fisheries are out, excluded, they're not part of this, don't even talk about fisheries. And the rest of us said, well, fisheries are part of the ocean, they're a crucial part of marine biodiversity, you can't possibly leave them out. So we ended up with this, what's rather, I think you call it constructive ambiguity, of this term saying, recognises that this process, being a negotiation, and its result, being the treaty, should not undermine existing relevant legal instruments and frameworks in relevant global, regional, sectoral organisations. And so the crucial question is, what does not undermine mean? Now, curiously, I could find only one instance in any international convention about not undermine, and that's in the fish stocks agreement. And it comes up, I think, 8 times there. And virtually every time it means reduce the effectiveness of. So they talk about things like should not undermine stocks, should not undermine the agreement, or should not undermine measures. So to our mind, in the High Seas Alliance, we say that is really the simplest way to think about not undermine. It means reduce effectiveness. Because to other states it simply means don't duplicate, or don't, or even keep away. But more specifically, I think the strongest other argument is that BBNJ will complement, add to the existing regime. So it won't undermine it, but it'll add a specific provisions or competence on marine biodiversity. And that's really, I think, almost the entire answer, in my view, to what undermine means, is that it means it won't reduce the effectiveness, and it will complement or add to the regime, and specifically through ways such as coordination and cooperation, providing expertise and scientific information, providing global guidance on effectively implementing ecosystem-based management measures, and effectively addressing cumulative impacts. So these are specific ways that we believe the agreement will enhance the activities and the competence of existing, things like, again, RFMOs, the IMO, and the Seabed Authority. But this is going to be, I would almost say, the defining fight of BB&J in one way or another. So it's a very, very important issue. Now, I want to turn to dispute settlement and compliance mechanisms, just briefly. And the reason I want to bring it up is that dispute settlement is, I believe, an absolutely vital component of good governance. Without dispute settlement, it's really hard to make the measure effective. And so it'll also be essential to effective implementation. And we already know that many sectoral or regional instruments have their own dispute resolution provisions, but you can't just rely on those because you'll get forum shopping, in other words, you can pick and choose where you go for your dispute resolution, your uncertainty, confusion and expense. Now, there is quite a lot to draw on in the fish stocks agreement, and I've cited, I think, the most important ones, things like the obligation to settle disputes by peaceful means, always a good one. Prevention of disputes. I think an important one is disputes of a technical nature and having an ad hoc expert panel, and I think there really is scope for determining specific matters of fact by some sort of an expert panel. Now, this has hardly ever been used with the fish stocks agreement, but to be fair, probably only because, I'd argue, because the fish stocks agreement doesn't have an institutional mechanism. And then there are procedures for disputes, the settlement of disputes in Article 30, and then provisional measures in Article 31. So I've just noted here that at the bare minimum, the agreement should provide for the ability to require or to request advisory opinions. And the reason I say that is that because if you don't have that in the agreement, then you can't do it. So it's really important that provision goes in there. But also, NGOs don't have standing, as I've learnt to my cost twice within the International Seabed Authority. They won't hear us, although they go as far as they can. But if we did specifically address it in the agreement, then we could get standing for NGOs to make representations before the Tribunal of the Law of the Sea. Just another thing to remember when we talk about arbitration, it's hideously expensive. We're talking millions of dollars, so for the group of 77 and in particular the developing world, it's really not an option. I've tried many times to get cases off the ground involving smaller states, and you're literally talking quite often $7 or $8 million just to get started with most 5 or 7 member arbitration panels. So just be very careful about arbitration. We have suggested a special chamber on marine biodiversity. There's already a seabed disputes chamber, so it's quite a simple matter for us to set up a special chamber. Closely related to dispute mechanism are compliance mechanisms, which we say should be integrated with dispute resolutions and be non-confrontational, transparent, flexible, cost-effective, preventive, and facilitative. And the reason we say that is it's really real politics. You will not easily get states to agree to, such as China and Russia in particular, and the US for that matter, to binding dispute resolution provision. Just won't get it. But there are two really good examples, and we often cite both the Aarhus Convention, which is the European Convention on Public Participation, as well as the Espoo Convention I talked about before with EIAs. Both of those have these, or to use the word of Aarhus, non-confrontational, non-judicial, consultative, and so what they've got is a special compliance committee which NGOs can make complaints to, and they do. And it's very, very active. It's in Geneva, and so if you argue that a country is not in compliance, in this case with the Aarhus Convention on Public Participation, then you can make a complaint to the compliance committee, which then hears it, but it doesn't issue a binding ruling, but it does try to solve the problem, and ultimately you can send a note through to the recommendation through to the meeting of the parties or conference of parties to try to find a solution. And other things have issued, they can issue a cautionary statement, again be non-binding, and build on compliance mechanisms. So this is something which hasn't been discussed yet. We keep on harping on about it. We're going to have to try to ramp up our efforts, but it's just been difficult because in the last IGC, as I said, that the President expressly said she didn't want to talk about dispute resolution and compliance mechanisms. So yeah, I think later on Nicola's going to talk about institutional arrangements, so I think I'll leave that one. Monitoring, reporting and review. Tony probably knows more than most people about this. A really important issue. In my view, a clearinghouse mechanism which has a lot of support on the floor, mainly for marine resources, but also for capacity building and technology transfer, can have an important role in data collection, handling, data analysis, and so on for monitoring. Some sort of global monitoring system to monitor data and report back. And really importantly, reporting by all relevant stakeholders, including organisations as well as states. Annual submission of reports, data and other information, and all being publicly available with opportunity to comment. And then after that, a review, something a 3 or maybe a 5-year review on the implementation of the instrument and effectiveness, and review of the mechanisms to ensure effective implementation. So again, this is something which hasn't had much airing yet because it wasn't included in the President's report and it wasn't discussed in IGC1, but it's something that is important, and we believe tying in these things such as dispute resolution, compliance and reporting and review, I think gives you a really good idea of where you're heading with the agreement, so we don't think it should be left till the very end. Responsibility and liability. Yeah, it's a shame that Simi's gone because she could talk for hours on this with great authority. One suggestion is there could be an enabling clause to elaborate a regime for liability and redress with the possibility of a fund, and other funds could include things like a rehabilitation fund, a contingency fund, a fund for compensation for restoration activities and so on, and a fund to support member states' cost of capacity building and so on. Yeah, a difficult issue, I think. I don't think we need to set our sights too high. I was involved in context of LMOs in developing a liability regime called the Nagoya Kuala Lumpur Protocol, and that took 10 years, and that was under the CBD biosafety protocol. So that's one reason, we don't want to go down that particular rabbit hole because you won't get any agreement anytime soon. But you could, at least in theory, have, like I said, an enabling clause, which is what they had in the biosafety protocol, to say that you shall establish a regime to elaborate a liability regime in the future. And just my last slide, talking about non-parties. The difficult question: what do you do about non-parties, and how do you make, if you've got an MPA, being the obvious example, how do you stop non-parties from sailing through it or fishing in it or doing whatever in it? And some ideas we've built on in the past is that to request non-parties to either become parties or to fully cooperate. You build on the approach used by the Fish Stocks Agreement, where activities are addressed, including things like requirement to cooperate for the conservation and management, in their case of straddling stocks, require respect for measures and so on. And we've noted Article 197 of UNCLOS establishes a duty for all parties to cooperate and preserve the marine environment. So even if you're not a party to the BBNJ, you still are bound by Article 197. So those are just some ideas for addressing non-parties. So there's a lot of other stuff you can be covered in, but I think it's probably enough on cross-cutting for now. So, any questions?